Good morning, everyone. Welcome to the January docket of the Court of Appeals. We're once again conducting this month's hearings via Zoom and YouTube. I thank the attorneys for participating in this manner. I'm presiding Judge Thomas E. Malone. We also have Judge Steve Hill and Judge Mike Boozer. We are the panel for this morning's cases. We have 3 cases on the docket this morning. I'll call the cases in the order of the published docket. Just a few preliminary remarks for the attorneys. We have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument. As the presiding judge, I'll be the timekeeper. Each side is given 15 minutes for your argument unless it's designated differently on the docket. The appellants, if there's more than one attorney per side, you need to decide in advance how you wish to divide your time. The appellant's attorney should let us know at the beginning of your argument if you wish to reserve any of your time for rebuttal. After the hearings this morning, your case will be deemed submitted for decision. And at that point, we will take the case under advisement and get a written decision out to you and your clients just as soon as we possibly can. So with that, I'll go ahead and call the first case this morning. It is from Sedgwick County. It is number 122280, entitled AV Homes LLC versus Amguard Insurance Company et al. And who do we have here for the appellant?
Thank you, Your Honor. Curtis Rago for the appellant, Amguard Insurance Company.
And for the appellee?
Don Peterson on behalf of Appellee AV Homes.
And Mr. Rago, do you wish to reserve any of your time for rebuttal?
Yes, 3 minutes.
That's granted. You can begin whenever you're ready.
Very well. I'll just briefly outline the facts. We'll not try to belabor them since you all are familiar with them. This is the underlying lawsuit was a dispute over whether or not Amguard's insurance policy provided coverage for a fire loss. In the course of adjusting the loss, the Amguard had serious questions concerning whether coverage applied due to possible misrepresentations in the application. AV Homes wound up filing a lawsuit in August of 2017. And the parties began to engage in discovery. After 2 days of deposition testimony given by corporate representatives of Amguard, the parties ultimately agreed to an agreed consent judgment. Amguard did agree to a judgment of about $1.3 million for the total loss. And in that agreed judgment, or consent judgment, they also agreed that a reasonable attorney's fee could be awarded under 4256 or 4908. That's the central issue here, as I'm sure you're aware. What was a reasonable fee? The central focus I would like to make would be really twofold. One is, as we do discuss in our appellant brief, the fact that that Judge Mitchell did not provide any real analysis of comparing the contingency fee with any kind of a lodestar analysis. Now, and certainly our argument was for the lower figure. The Johnson versus Westhoff case certainly says that, and other case law indicates that a court may essentially award the contingent fee or the equivalent of a contingent fee in assessing what's reasonable in a transfer of fees, a fee shifting to an insurance company. However, no one factor should dominate. Of the 8 factors that are laid out in Rule 1.5a, no one factor should dominate. One thing that was brought out during the hearing was some discussion concerning the number of hours that plaintiff's counsel had spent on the case. It was something like a little over 600 hours, 605 hours, I think. And if one were to apply, just a rate, an hourly rate for Mr. Graybill or Mr. Hazelwood, that came closer to a $200,000 figure as opposed to $514,000 that Judge Mitchell essentially awarded for that part of the judgment. There's no discussion in comparing the lodestar analysis to the contingent fee in determining if it's reasonable. The memorandum decision does discuss the fact that a contingent fee is regularly, a 40% contingency fee is normal in this area. It's not unusual, and that's certainly one of the factors that goes into it. But even the plaintiff's expert, Blake Stewart, during the course of the hearing, did testify at one point that in his experience, even with mass torts, class actions, courts were not using lodestar analysis as much and were using and were effectively applying more of a contingent fee analysis. But even he testified that the courts typically would do a lodestar analysis and do some calculation that way to weigh, is the contingent fee reasonable? The memorandum decision doesn't have any discussion about that, about any kind of a, how many hours did plaintiff's counsel spend on the case? What were the hourly rates? What would have been a basic calculation in a yes, Judge Hill?
Counsel, my question to you is this: is my understanding correct that you're arguing that a lodestar analysis is required by the court in this situation?
I don't know that the law mandates that it is required, but certainly we believe it is part of what should go into the process of evaluating, is that fee reasonable?
In other words, you're telling us that you think that in order to determine whether it's a reasonable fee, some sort of analysis that's similar to a lodestar analysis is reasonable. Is that correct?
Correct. We believe it's proper to consider, okay, how much time was spent, what would be the normal rate.
So where did the district court get it wrong here?
Well, the memorandum decision doesn't lay out any discussion about that analysis. That's what's lacking, which leads us to, just in reading the opinion, seems to be that Judge Mitchell simply applied the contingent fee, and there's no discussion whether she weighed that in light of the amount of time, the hourly rate, or some similar kind of analysis in evaluating the reasonableness of that.
The judge's opinion does not say, though, that she used just the contingency fee in her analysis, does it?
No, it does not say that. I cannot suggest that. One thing about in the award, the total award was $720,000, of which $514,000 would be the 40% contingent fee on the 1.3 million judgment. And then another, I think it was about $206,000 on top of that, which would be the fee for fee part. And certainly the laws recognize that the fee can be awarded in the process of litigating the reasonableness. But even there in the hearing, plaintiff's counsel, Mr. Hazelwood, did testified that they spent about 100 hours, 95 to 100 hours on the litigating the reasonableness of the fee up to the point of the hearing before Judge Mitchell. And if you do a basic analysis of that, that comes to around $30,000 for his time. You run into applying a multiplying factor, that's like 7 times what the amount actually awarded was, on the order of close to 7 times that amount. So that's where we think. Excuse me, sir.
I just I have one further question for you. Exactly what relief are you asking from us?
We are asking that the court review the record and assess what the reasonable fee is. The appellate court is also an expert on fees, so therefore we have not asked for remand. What we have asked is that the court would address that issue. It's yourself.
So basically you're asking us to substitute our learned opinion for what the district judge ruled.
If you agree with us that she abused her discretion by failing to provide any analysis as far as whether the amount awarded in light of the time, the status of discovery and so on was reasonable.
Thank you. Thank you, counsel.
Thank you. A little bit hard to keep track of my time, but in my time remaining, I did want to also mention another factor or another issue that's been briefed. And that specifically is AV Homes didn't just sue Amguard, they also sued M&M Financial. The claim against Amguard, of course, was for breach of contract over coverage for the fire loss. There was an alternative claim then against AV Homes for, if Amguard were to prevail and be able to avoid coverage, and they had a claim against M&M as the broker that placed the policy. When Amguard entered into the consent judgment, and they did agree that a reasonable fee could be assessed. What they didn't agree is that fees that were incurred in also pursuing a claim alternatively against M&M should also be assessed against it. There's no suggestion that AV Homes' claim against M&M would potentially involve a recovery of attorney's fees against M&M if that is the way it would have played out. And the law does say, we cited the Despiglieri case, if you got more than one claim for which some may be an entitlement to recovery of attorney's fees and others not, there needs to be some sort of a separation, some sort of a allocation, how much time was invested pursuing one claim versus the other. And while Amguard, I assume, was the target defendant, certainly counsel for plaintiffs spent time preparing the theory, the claim against M&M. There was discovery served on M&M, discovery received from M&M, and certainly the record includes evidence of a number of conversations, communications with M&M's counsel about the lawsuit. Again, Amguard, in their agreement to accept a reasonable attorney's fee, did not consent that they should be entitled for fees that AV Homes may have incurred in pursuing their alternative claim against M&M. Those are I think that's really the main 2 points that I have in the time I have. So unless any of you have any other questions, that's the main points I wanted to make here.
Apparently not, so we will now hear from counsel for the appellee.
Thank you, Your Honors. The scope of review really is what decides this case. You look at the briefing we did, we think this case is decided by the Supreme Court's decisions in Johnson and Consoliver. And in those cases, the court emphasizes how important the scope of review is, and that at this stage, it's not de novo. In Johnson, they said, yeah, the fee is high, but we're not substituting our judgment. The question is whether the lower court did something inappropriate, and Judge Mitchell did not.
Counsel, let me interrupt you with a question.
Yes.
I just have a preliminary question about the nature of your blended contingency fee agreement. I know that courts usually recognize contingency fee agreements because of the financial risk involved to the attorney.
Yes.
If if the attorney recovers nothing, then the attorney, if the client recovers nothing, then the attorney gets no fee. As I understand the facts in this case, you had a blended contingency fee agreement with your client that allowed you to recover 40% of the recovery or the hourly rate, whichever is greater. Am I correct on that?
That's correct, but it's contingent.
Well,
In other words, you don't get a fee if you don't prevail.
that's not how I would understand that. You either recover, you get 40% if you do recover, or your hourly rate, whichever is greater. That would seem to indicate to me that if there's no recovery at all, the client still owed the hourly rate.
That's not right. That's not what the agreement says.
All right,
It's contingent.
all right.
Yeah.
So you have to recover something.
Yes.
And then if you make a recovery, it's either 40% or the hourly rate, whichever is greater.
Yeah. And limited to the recovery amount. It can't be everything. It can't be more. Well, I take that back. The crucial point here is that it is a contingent fee, and the lawyer gets paid nothing if the client doesn't recover.
And you're sure the agreement spells that out? I guess I'll look at it again, but it makes that clear.
Yes. Yes. I don't believe that's been in dispute. I don't believe Amguard has challenged that.
Even with that blended nature, though, isn't there less risk for the attorney under your contract than just a normal, straightforward contingency fee agreement?
Well, the answer to that is I don't believe the answer to that. The answer to that is probably no. The reason that it's written that way, your typical, well, let me back up. This is in a context of an attorney fee shift, okay? And virtually all of the situations where the legislature has adopted an attorney fee shift, it's precisely because the amounts in dispute often are so small that no lawyer could take the case on a contingency fee basis alone if all that was in that the client would be able to pay is from the amount in dispute. So you'll see attorney fee shifts in wage and hour litigation. Okay, frequently clients, the loss is $2,000–$3,000, and the legislature knows, Congress in this case, under the Fair Labor Standards Act, knows no lawyer can be hired on a contingency over $3,000. Similarly, Kansas has a fee shift statute on property damage only loss. If I'm in a car accident and the claim is only property damage, it's probably going to be a relatively modest amount. And the legislature has put a fee shift in there to allow the court to award attorney's fees. And if the attorney fee were limited to a percentage of the recovery, that fee shift wouldn't work.
I'm still a little confused. And I'm sorry for being so ignorant, but I'm a little confused on how your blended contingency fee agreement worked. As I understand, based upon your hourly rate, your fees would have been about $189,000. Is that correct? All right. Let's say you had settled this case for just $100,000.
Right.
Then the 40% of that would be $40,000. But your agreement is, this is what I don't understand. Your agreement says you recover 40% contingency or the hourly rate, whichever is greater. So if you had settled this case for $100,000, what would your fee have been?
Well,
It sounds like it would have been $189,000. That's the greater of those two amounts.
right. I think typically it would be limited to the amount of the recovery and no more. But I want you to understand that conceptually, more broadly speaking, there are cases where the amount in dispute is not a whole lot of money. And insurance companies or defendants in those cases can exploit that by, they can take advantage of that because if the client can only, if the court cannot award a fee greater than the amount in dispute, the client would never be able to hire a lawyer. So in fee shift litigation, you'll see it frequently. The concept of where the statute provides for a fee shift, it's precisely where often you will have a relatively modest amount in dispute. And the court should be allowed to award an attorney fee that might well exceed by far the amount in dispute, precisely so that lawyers will be encouraged to take such cases, small cases. You see this all the time in wage and hour litigation. There would be no wage and hour litigation, virtually none, if the court could not award more than what is in dispute. Where there's an important public policy at stake, the legislature, to even the playing field, okay, has provided that courts can award an attorney fee.
I know we have lots of cases out there on contingency fees. Can you cite one case that addresses a blended contingency fee like you had here? Do you know of any?
Well, I can tell you that my contract is a little bit different than this, but has the blended language in it in every piece of federal.
I'm in a published appellate case that I could read. I presume none are cited in the briefs that I saw, so I take it you're not aware of any.
Well, this was never raised below as a mattering. It was not raised on appeal as mattering, and so I haven't researched to try to.
Well, you're asking us to approve the attorney fees, and I think it's an issue here I can at least bring up. My fundamental question is that we recognize contingency fee agreements because of the risk involved to the attorney.
Right.
But it seems to me that in your case, there's at least less risk involved than if you had just had a straight 40% contingency fee. And so perhaps we should give the contingency fee agreement less weight.
Well,
now, tell me why I'm wrong on that.
Yeah. So for one thing, this is if you look at the cases that talk about, in Consoliver, for example, Justice Stegall makes the point that the lawyer will not be paid unless they prevail. That's the nature of a contingency fee contract.
Right. And
that's the sort of the risk that we have to avoid hindsight bias to avoid. That we end up in these discussions only in cases where the plaintiff prevailed. But by the time the client hired you, they already had a 400. Let me look at my notes here.
A $440,000 settlement offer was already on the table before you even got hired. Isn't that right?
Well, that was being made with a 48-hour time limit to leverage a payment that
But it still seems like it's pretty clear that you weren't going to walk out of this without any recovery at all, like in a car accident case where that can happen. It
Well,
it seemed pretty obvious that there was going to be a recovery here.
I could not disagree with that more.
They offered $440,000 before the client even hired you.
And they were litigating and taking the position that nothing was owed.
Mr. Peterson.
I'll just ask one final question because I want to nail this down. On my hypothetical, if you had settled this case for $100,000 under your attorney fee agreement, you would have still wound up getting $189,000 in attorney fees. That's correct, isn't it?
This particular agreement does not provide for that. The last sentence of it says it's capped at the recovery. My point has been, there are many contexts within which fee shifts, the whole point of the fee shift statute is to allow a court to award more than what's in dispute. Our contract did not provide for that. The point of my comment, so let me be clear. The fee is capped at the recovery in this contract. I have contracts in other contexts that tend to be smaller cases where my contract does not provide for that. And it's precisely because the amounts in dispute in wage and hour litigation, for example, are almost always so little that no lawyer could take them for a percentage of what's in dispute. But the
Counsel,
yes,
let me ask you a question. So it's in answer to Judge Malone's inquiry, it's your position that if you had run up $189,000 in attorney fees and the case had been settled for $100,000, your fee on that case, that result would have only been $40,000 and would not have been $183,000.
no, it would have been the 100. It's capped at the recovery.
Oh, it would be, okay, so it would be $100,000, not $189,000.
Right. The idea is the client can be in no worse position than when they came in.
All right.
And by the way, when they came in, that 48 hours had lapsed. The 48 hours had passed. So the offer was not on the table anymore.
Well, Mr. Peterson, it looks like to me that your contract merely has a different way of computing your fees. You have to win in order to recover.
That's right.
If you don't win, you're not going to recover a dime.
That's right.
And so it's either going to be 40% or the hourly rate, whichever is greater. You still have to win the case.
Still have to win, and the hourly rate is capped at the recovery. That's how this contract's drafted. My point about there are circumstances in which having that cap doesn't make any sense, is that there's a lot of litigation in fee shift world where the amounts in dispute are small, but the statute is written precisely to encourage lawyers to take it. So the idea that the fee should always be capped at the amount of recovery, that is not a one size fits all. But in this contract, it does have that.
Now, I asked your opponent this question, and I want to ask you back to what the judge did in this case.
Yes.
Is a lodestar analysis required in determining the reasonableness of attorney's fees in Kansas? And did she engage in that analysis?
Well, I think the judge almost certainly did. It's not spelled out in that opinion, but these things were argued by the defendant, and there was testimony even by our own expert that discussed these things. And so I would find it, I'd be well, I'll put it this way. There's nothing in the opinion that suggests the judge was rejecting any particular points raised by either side. The judge was looking at everything, and she says she did. Furthermore, though, the specific answer legally, I believe, is that that's not required. I think she did consider all of that, and including the lodestar type analysis, but it's not required. And the reason I say that is if you look at the Johnson case, for example, the court never breaks it down into how much does that come out to be per hour. You have to go do the math. That's not in the opinion anywhere. It's just not required as a part of the analysis to get to a result. And then one other thing is that you know, I think arguably this kind of a point about an evidentiary type analysis is really not what this appeal was raised about. I mean, it's really kind of a waived thing. Challenges to inadequate fact findings have to be asserted. I mean, as I read their brief, it's about, you know, the judge didn't balance it right, which, you know, gets us back to the when you get to the heart of it, and I think our discussion about the fee contract here and the various considerations that what's reasonable in one case might not be in another, and small cases versus big cases and all of that illustrates why Rule 1.5a has a factor analysis, not some mathematical formula. It's a factor analysis, and it's because the landscape of attorney fees is, there are too many possibilities, too many variables to say we're just going to in advance establish a formula that can be applied in all cases. And that's why it's discretionary. It's left to the good judgment of the district judge who sees everything about the case, is familiar with the case, has seen the witnesses, and it's their job to do this balancing that's required under Rule 1.5a. And Judge Mitchell did that. And the outcome, I mean, she heard the evidence, she considered the evidence, she wrote an opinion explaining it under the factors of the rule. And the outcome, although Amguard has argued, well, it comes out to $800 an hour or something, and wow, that's a lot. That's about half what was approved in Johnson if you break it down into hours. So it is not out of the bounds of reasonable, according to the Supreme Court precedent. And this court should be, in my view, this court should be loath to start substituting its judgment on a factor analysis where the law is that is not de novo review, and you have to defer to her good judgment as long as she doesn't abuse it. And there's no reason to believe it was abused here. By the way, Amguard never gave Judge Mitchell an alternative number. They never once proposed, here's what we think an appropriate fee would be. Never did that.
All right, counsel, thank you. You've used a little bit more than 15 minutes.
Do I have a little more time?
Yeah, go ahead and wrap up.
Let me wrap up with this. One of the things that's happened here in this case is that Amguard has said, oh, you know, you devoted too many hours to this case. You sent 2 lawyers to the deposition. It's one deposition. Well, it wasn't, you know, yeah, it's a 30B deposition, but it had numerous topics, and my partners divided those topics up, and so did Amguard. They provided numerous different witnesses to talk about the different subjects in the Rule 30 deposition. So technically it's one 30B deposition, but it's multiple witnesses, and they divided it up between them, which makes total sense. And our expert, Mr. Stewart, testified that that was reasonable under these facts. And there's no other testimony that says that was unreasonable. But in Consoliver, Justice Stegall, in a unanimous opinion, said we have to be very careful about hindsight bias, that this risk that the lawyer might not be paid at all is real. And it is not a given that you're going to get a recovery in cases that are contingent. And that was true here. It was being vigorously litigated. But I want as a part of the hindsight bias on this issue of, was it reasonable to send two lawyers? I would like to direct your attention to some testimony from one of the co-owners of AV Homes. This is Adriana, the wife. And she was asked, what was the impact of this failure of the insurance company to pay what it owed to her? What did this look like to them? And her answer was, well, we lost 20 apartments. With that, we lost the income from 20 apartments, which was probably $8,500 a month. So we used the little savings that we have to pay for that, so we couldn't be in a bad position with the bank. So it affected us significantly because at the time our cash flows were negative, basically. So for the last 2.5 years, we've been losing money, cash flow, negative income last year. Well, how has that affected your family? Probably it is hard to explain unless you understand it, unless you live it. But we invested our life savings of 25 years to work in this company so that because we wouldn't hire a property manager. Well, 20 years of work in this company. So because we couldn't hire a property manager, we couldn't afford it anymore. So Julio has been working 12 to 14 hours a day because in addition to his full-time job, he's also doing the property manager job, which has basically affected our life and our family. That also has created a lot of worry and anxiety, and she goes on. So it's in the context of that impact that we're having to make decisions about, well, do we send two lawyers to this 30B deposition to try to break the case open? You know, we're sitting here today, it's 3.5 years post-fire, and our clients are still waiting to be reimbursed for the attorney fees they've already paid. They paid the $514,000, and they were happy to do so. That was their testimony. They thought that was fair. They've paid it. They've received 60% of their money on a loss that Amguard has now admitted it had no defense to. It was pushing them around. And if lawyers are not encouraged to bring cases like this to protect people like this, companies are going to be emboldened to keep doing that sort of thing. I'm proud of my partners for stepping up and protecting these people. And you can't even compute what the hourly rate is yet because here we're still arguing this case. 3.5 years later, we're still working on it. It's a fair fee. It's within the range of reasonable, according to Johnson. Judge Mitchell applied all of the factors appropriately. It was contingent. If we had lost, we wouldn't have made a penny. So we would ask that you approve Judge Mitchell's fee and acknowledge this is a de novo review where it should be left to the, it's not a de novo review, and it's abuse of discretion standard, and you should accept the determination made by Judge Mitchell after hearing all the evidence. Thank you.
All right, thank you, counsel. Mr. Rago, I'll give you 5 minutes for rebuttal.
Very well. Your Honor, first of all, I would note on the Johnson case, it is evident that the court conducted some sort of analysis of the amount of time and work that had gone into it in weighing the fee. And admittedly, the court in Johnson did affirm the trial court's award of attorney's fees and said, yeah, it seems high, but we won't second guess on the abuse of discretion standard. Nevertheless, there was some analysis of, okay, how much work went into this, how much time, and so on. And that's one of the things that distinguishes this case. There was 2 days of testimony of corporate witnesses. That's it. There were no other depositions or anything of that nature other than written discovery that went into it. I'd also then would like to point that the plaintiffs rely a good deal on the Consolver case. And while that is a case that has discussion about contingency fees and the role they play and the factors under Rule 1.5a, one thing about Consolver, it's really not on point to this case because it's not a fee shifting case. That was a case of a dispute between two plaintiffs' lawyers over how much each would get out of a given contingency fee. That was a personal injury case. The Pistotnik firm took on the case, took it up through mediation, and settlement negotiations broke down. And under that contingent fee, it would have gone from a 1/3 contingent fee to 40% if they went to pretrial. The plaintiff fired the Stocknick firm and then hired somebody else who eventually reached a settlement. And the fight there was, how much does the first lawyer get out of that contingency fee? And a good part of the Consolver decision was discussing whether or not the whole principle of quantum meruit and unjust enrichment should apply in that kind of a setting. So it's a case that has merit when you're looking at a dispute between two lawyers. How much does each get out of a given fee and the amount of work? But it's not a fee shifting case in terms of a dispute with an insurance company and therefore what would be appropriate as far as an award under 4256 or 4908 or some similar statute that's a fee shifting to an insurance company as we're dealing with here.
Counsel, below or on appeal, did you raise specifically the argument that Judge Malone has raised here today?
I don't believe so. I'm not aware, at least, that that specific argument was raised below.
Your primary argument has been just with the notion of putting over-reliance on a contingent fee approach not tied to the lodestar.
That has been our central argument. That's correct. That there needs to be some, in the court's rendering the decision, there needs to be some discussion, whether you want to call it strictly lodestar or some evaluation of the time, the expense, how would this have played out under an hourly rate, some evaluation that way. And then also, as was pointed out as well, AV Homes didn't just sue Amguard, they also sued M&M. And even though Amguard's agreed to a reasonable fee for the claim against it, it did not consent that it should also be paying for fees that plaintiff's counsel would have incurred in their time and work in pursuing M&M in their alternative claim. So that part is missing, and that is an abuse of discretion because there's no suggestion that plaintiffs would have been entitled to recover attorney's fees from M&M or that somehow Amguard should be liable for any activities on the part of M&M as far as be liable for fees in pursuing the separate claim against M&M.
Did you bring that up before the district judge?
I believe that was briefed before the judge. I don't recall, I wasn't involved in the hearing itself. I don't recall that the hearing, whether that was discussed directly during the hearing itself, but I believe it was briefed.
I don't think she addressed it in her opinion, did she?
She did not. So.
All right, counsel, thank you very much for your briefs and your arguments. We certainly appreciate everything. We will get a written decision out to you and your clients just as soon as we possibly can. Thank you. And with that, this hearing is adjourned.